Washington voters have passed Initiative 502, and beginning December 6th, it is not a violation of Washington state law for adults over 21 years old to possess up to an ounce of marijuana or 16 ounces of solid marijuana-infused product like cookies or 72 ounces of infused liquid like oil, all for personal use. The initiative establishes a one-year period for the state of Washington to develop rules and a licensing system for the production and sale of marijuana. While legal in the state of Washington, beginning on December 6th, Oregon law has not changed with regard to marijuana possession, distribution, or manufacturing. It's important, though, to understand that under Oregon law, possession of less than 1 ounce of marijuana is classified as a violation. It is not a criminal offense, and people cannot be arrested or jailed for the possession of less than 1 ounce of marijuana. Possession of less than 1 ounce of marijuana has been a low law enforcement priority for 35 years in Portland, and this will not change due to the new Washington law. What is not a low law enforcement priority is driving under the influence. DUI remains a high priority for the Portland Police Bureau. Here are some important questions and answers about the Oregon impact of the new Washington law. Yes, the Oregon Medical Marijuana Program allows for cardholders to possess certain amounts of marijuana. It does not dictate where cardholders can get it, and there are no changes to the Oregon Medical Marijuana Program because of Washington I-502. No, possession of less than 1 ounce of marijuana is an Oregon violation, and you could be subject to a citation similar to a traffic ticket. No, while Portland police do not prioritize enforcing citations of less than an ounce of marijuana, smoking pot in public places is strictly enforced. Don't do it. Even under the new law in Washington, you are not allowed to smoke marijuana in public places. Washington is developing rules and a licensing system for the production and sale of marijuana, which may eventually lead to the existence of cafes or businesses where smoking pot is allowed. Until then, if you must consume pot, then do so in the privacy of a residence. Unless you are operating a vehicle, bicycles included, you cannot be cited for the consumption of marijuana. If an officer believes you're driving under the influence of a controlled substance, they will conduct a field sobriety test and may consult with a drug recognition expert. If officers establish probable cause, they will bring you to a precinct and ask your permission to draw your blood for testing. If officers have reason to believe you're under the influence of a controlled substance, they can get a search warrant for a blood draw from a judge. In a serious injury crash, if law enforcement suspects that the driver is impaired by drugs or alcohol, officers will apply for a search warrant to draw and test the driver's blood. It's important to know that driving under the influence is a criminal offense in Oregon, and those driving under the influence of marijuana or other drugs can be arrested and jailed for DUI drugs. While DUI alcohol is generally when a driver's blood alcohol content is 0.08 or more, there is not the same threshold for marijuana or other drugs. The threshold for DUI drugs is impaired to a perceptible degree. Get a designated driver, take public transit, or plan to stay the night in Washington. Yes, but you can still get a DUI drugs while riding a bicycle. Marijuana is still a Schedule I drug under federal law, and marijuana possession and sale remains illegal under federal law. The Portland Police Bureau cannot predict or control the enforcement activities of federal authorities. Much like existing fireworks laws, what is legal in Washington is not legal in Oregon. In other words, if it goes high in the air or it gets you high, you should probably use it in the evergreen state.